Let's have a chat about this with someone who knows a fair bit around this subject. Nick Freeman, known as Mr. Loophole, is a celebrity defence lawyer. Nick, good morning.
Good morning, Sally.
Talk us through, first of all, this exceptional hardship defence, which you've used many times, I'm sure.
Well, yeah, it's mitigation. It's not a defence. So, in short, if you get to 12 points on your licence, the court has to disqualify you. It's forced to disqualify you for a minimum period of 6 months. It can disqualify you for more. It can't disqualify you for less. So that's the basic premise. But Parliament decided to give people who commit what they regarded as relatively trivial offences one more chance if you could establish exceptional hardship. And the burden of proof is on you, the driver, to establish that exceptional hardship. You can argue it once in a 3-year period. And if you can argue it, if you succeed in arguing it, what that does is it gives the court a discretion which they otherwise wouldn't have. So in other words, once they say, from a balance of probabilities, there is exceptional hardship, they can then say, yes, we hear there's exceptional hardship in this case, but we're still going to disqualify you. They can disqualify you for any length of period they want, or they can disqualify you for no period. It's entirely within their discretion. So that's the basic premise. And one of the most persuasive things when you're arguing exceptional hardship is not you, the defendant, would suffer hardship, but other people, and that's what Steve Coogan argued, innocent victims would be affected. And presumably the court found as a fact that the innocent victims, the other people who were employed or subcontracted to by his film company, they would have suffered exceptional hardship as a consequence of the delay or cancellation of this particular film project. Now, I wasn't in court. I didn't represent him. I don't know what evidence was presented to the court. It has to be evidence on oath in terms of satisfying the court that the other people who presumably earn reasonable livings, they would actually suffer exceptional hardship. Yes, they might well lose this particular job, or it might be delayed or cancelled. But would the consequence of that actually result in exceptional hardship, or would it simply be inconvenience to them and aggravation? I don't know. Maybe he presented documentary evidence to the court in relation to the 15 or 20 potential people who might have been affected. To establish exceptional hardship, the court really should see cogent evidence that these people would suffer exceptional hardship. And simply the fact that their contract will be cancelled does not mean per se that will be exceptional hardship. What we're looking at is what would the consequences of that cancellation be? And I don't know that because I wasn't in court and I'm not privy to the evidence that was presented to the court. So that's basically the legal premise. What's significant here is he was disqualified for a lesser period. So the court said, yep, there's exceptional hardship. There are innocent victims who would be affected in their view. So we're going to disqualify you for 2 months. And the significance of that is, if you were disqualified for more than 56 days and you then fall foul of those totting up provisions again within a 3-year period, the minimum period of disqualification jumps from 6 months to 12 months. So they have sort of hung a sort of Damocles over Steve Coogan's head, because if he's going to tot again during the next 3 years, he will be looking at a starting point of 12 months and not 6 months. So that's basically the legal scenario.
Now, there's lots of people listening to you right now explaining it all very clearly, and they will be automatically thinking, well, if these 15 to 20 professionals who were lined up to work on the series, they are going to suffer under the fact that if Steve Coogan was given the 6-month ban because the filming would be canned, then they're probably thinking, well, that Steve Coogan should have thought of that, shouldn't he? And if he's that worried about his team, then he's probably got the money to be able to sort them out and say, we'll do it at a later date.
I'd agree with you on both counts. But from a legal perspective, when considering exceptional hardship, if the situation was, well, Steve Coogan said, well, look, if this is cancelled, I will pay for them, then they wouldn't suffer exceptional hardship. But as I understand it, the evidence presented indicated that the contract will be cancelled and they would lose this employment, and that in turn would cause them exceptional hardship. So anybody who's going to be liable to any period of disqualification should have thought about it beforehand, but we're all human and we all make mistakes. And that's why Parliament, in its wisdom, gave people who commit what is really regarded, I'm not seeking to trivialise it, but he was doing 36 and a 30. I'm not saying that's right, I'm not condoning it. But Parliament said, look, if you do that, we're going to give you one more chance. If the consequences are so catastrophic, for example, you can't pay your mortgage, you lose your house, you can't feed your kids, whatever it is. And here what we're saying is, well, these poor guys who are nothing to do with his criminality, they're completely innocent of that. They're now going to lose this contract. And the consequences of that loss would cause them exceptional hardship. Now, I don't know what evidence was presented to the court to establish that, and it would be fascinating to know, because I suspect that nothing of an individual nature in relation to each and every, I'll refer to them as employee, I think they're independently employed, was presented to say what the consequences would be to those people if they actually had this contract delayed.
There's very little sympathy for him on social media, which, as someone who is very well known for defending very high-profile figures, that won't surprise you at all, Nick, of course. But you've mentioned about how, this is something that would be considered for, members of the general public. It's not just celebrity status that this can be argued.
Absolutely not. Look, for a celebrity to argue exceptional hardship is particularly difficult. It's a real uphill battle for the very simple reason that most celebrities do have wealth, and if they get to 12 points, the courts say, well, can you afford a driver for 6 months? Yes, of course I can. It wouldn't work in this particular scenario for the reasons you've already referred to. If you're a celebrity, then it's very hard to argue exceptional hardship. It militates against you, and it's much easier for Joe and Jane public to succeed with this argument than it is for a celebrity. The celebrity status, I understand from the public's perspective, they think he's being afforded preferential treatment because of his celebrity status. In fact, in this case, it's despite his celebrity status that he's being afforded it. It doesn't assist him in any way, shape or form. It's purely because of these people losing their jobs and the consequences that would flow from that. So that's the position. A presenter on another radio station yesterday said, well, look, he was driving a Porsche and he was a car enthusiast. Well, he is a car enthusiast. At the end of the day, he said, I plead guilty. I was doing 36 and a 30, and I've now done it on the fourth occasion in 3 years. He's held his hands up. He's apologised. He obviously drives a massive mileage. He's made a mistake. The law accommodates that mistake under this particular section, and the courts found, yes, we accept those facts. We have a discretion, and this is how we're going to exercise it.
Now, I know you famously refused to defend your own daughter against a speeding offence because you wanted her to learn her lesson. So is Steve Coogan or any other of these high-profile figures, are they learning a lesson?
You're going to have to ask them that, I'm afraid. I'm not in loco parentis of Steve Coogan, but I am perfectly entitled to say to my daughter, listen, she passed, she'd committed one offence within 2 years of taking a test, and I thought, I don't want to help her because if she commits another offence within 2 years, she's going to have to retake a test. And I know that would have been particularly galling for her. And to her credit, lots of people, lots of very well-known lawyers offered to defend her for nothing. And she said, no, I'm going to learn my lesson. And I think that's all credit to her for doing that. One hopes that when you are brought before the court and you're exposed to this amount of publicity, and it's not positive publicity, is it? There's no good that comes from this. They actually, in their quieter moments, think, I need to behave more responsibly. I need to set an example because everything I do, people look at it and people will criticise or approve. And he's probably let himself down here, and it's not done himself any favours. Even though in court he's had a reasonably favourable outcome.
Nick Freeman, great to talk to you this morning. Thank you for giving us your thoughts on this as well. Celebrity defence lawyer Nick Freeman, also known as Mr. Loophole. This is BBC Radio Derby.